Looks like the parties are ready. We are here in the matter of the estate of Jack Rose versus Oakland Healthcare Management. And it looks like both parties are ready. Mr. Johnson?
Good morning, Your Honors. May it please the court, opposing counsel, I'm here with my co-counsel and father, Jon Johnson. In this case, there are three major legal issues. There's legal error from the Court of Appeals when they required intentionality for recklessness. There's procedural issue when the Court of Appeals decided causation and brought up that issue sua sponte. And the summary judgment error, that the evidence was viewed not in the best light of the non-moving party, which was the plaintiffs in this matter. First, I want to talk about recklessness. The Court of Appeals ruled that the estate failed to show intentionality. Intentionality is different from willful misconduct, and it's important in this case to look at the statute where it says, or recklessness or willful misconduct. When the Court of Appeals rules that intentionality is a component of recklessness, it conflates those two terms. Rather than the disjunctive or, it creates a surplusage in the language of the statute where willful misconduct and recklessness functionally mean the same thing.
Issue that the act was intentionally done and negligence didn't lead to that act? I mean, isn't that really what our focus is?
Our focus is that the act, and we argue, the plaintiffs argue in this case, that the act itself is reckless. One issue that, with the Court of Appeals opinion here, is that in their analysis of recklessness and intentionality, they're assessing the intent, that the intent was to infect the residents of Oakland Manor.
We have the case on further review. We're going to do a decision. We have an opportunity to clean up language that the Court of Appeals may have made that we don't agree with. I want to focus in on the evidence of recklessness, and that is really the affidavits from the nurse. Is that correct? That's what the evidence is. Here's my concern. It's a medical malpractice case. Normally what we would see where the threshold is negligence, you'd see a discussion of the standard of care, you then have an explanation why that standard, what the standard of care required, and that the standard of care wasn't met. Here, I don't see that in those affidavits. I just say there were, it's my opinion the death of Jack Rose is due to the negligent care and wanton violation of federal, state, and facility regulations. That seems to me very conclusory, and I question whether that's enough to get past summary judgment.
I understand your question, Your Honor, and I believe that the dispositive facts here are that even if the affidavit is sparse, that the estate is still allowed to supplement after the fact. But in addition to the affidavit itself, we argue that the affidavit incorporates the CMS reports, which details...
Well, why aren't those hearsay?
Your Honor, in Kindig versus Newman, on causation, Kindig held that evidence need not be admissible at summary judgment. That
problem, though, with that Kindig line of reasoning is that they were actually talking about a guy who was repeating something he'd heard, okay? And so the point in Kindig really is that even if it's not the actual testimony of a person, because it's an affidavit format, right, or whatever else, it still has to, there has to be something that's not hearsay that's being reported. If you have hearsay, it's being reported. And I feel like this is really close to that situation of At the end of the day, what you're offering is hearsay.
And I would disagree. I would still point the court's attention to that Kindig, because in Kindig, even though you have the hearsay, it would be resolved when the court analyzes that evidence at trial. And if admitted, the jury would have an opportunity to evaluate the credibility of it.
Argue with Justice May about his own opinion, but I read it. I kind of read it the way he does. I think what it says is the format doesn't have to be testimony. You can have an affidavit. You can't walk into court with an affidavit. You have to have people who test either live testimony or a deposition where there was an opportunity for cross-examination. An affidavit is good enough. But then, and you have an affidavit here, but the problem is those reports, Kindig does not say you can get something that's otherwise hearsay in, I think that's going beyond what the case says.
The issue is that to resolve this case on summary judgment is premature.
So what about the hearsay exception for public reports?
The CMS report is a federal regulation report detailing the violations that we're seeing at Oakland Manor. The hearsay exception may apply, in which case, and we intend to pursue that exception. However, to go back to the previous points, the court's decision to uphold the grant for summary judgment is premature before we have an opportunity to address the admissibility in the exceptions to hearsay that apply to the CMS report.
To that, but then can you address kind of the exception to the exception about investigative reports and what is this CMS report? Because on the first page, it looks like it was done in response to some sort of complaint because it references complaint numbers, but I really don't know much about it. So can you enlighten me on that? It says on the first page, it was done in response to complaints 92564C, 9298C, and then it's got a couple others. And then it says the complaints were substantiated. So what is that referring to?
That's referring to complaints that were submitted that were the basis. I believe your contention is correct when it says that it's based on those complaints. However, I believe when
this whole report was generated in response to these 1, 2, 3, 4 complaints. Is that right?
No, they had regulators on site that made observations in reviewed records for Oakland Manor. The complaints were merely the trigger for the investigation that validated the substance of the complaints.
Somewhat, because the public records exception, would allow factual findings from a legally authorized investigation, but not investigative reports, not factual findings resulting from special investigation of a particular complaint, case, or incident. So it has to be more of a kind of a regular thing that was regularly done. But if it was in response to a particular complaint, then it sounds like it's a problem on my reading of the rule.
And in response to that, I would say that I still think that it is premature for the court's assessment when it comes to summary judgment.
District Court to delay the submission of the summary judgment motion so you could do discovery?
I'm unsure. My co-counsel, I could have a quick second to confer with co-counsel to confirm whether or not that was specifically requested.
I assume co-counsel may have tried it. Am I right?
We didn't ask for a delay.
There was no delay sought in this matter, Your Honor.
Questions of admissibility of the CMS report. What are the best facts that you had to show willful or reckless misconduct by the defendant?
Contained in that CMS report. And so that CMS report contains several specific allegations, including 11 out of 13 instances that were observed. The healthcare workers at Oakland Manor were not exercising proper hand hygiene. There was a lack of sanitation of equipment between patients. There was a lack of switching gloves between care patients.
Negligence, but how do you get up to the higher level of willfulness or recklessness?
You get to recklessness because of the nature of the pandemic. Now, this is a healthcare facility. This is a skilled nursing care facility that would have gotten and did get guidance from federal, state, and local authorities in March. So we're not talking about an instance in March. I know in the defendant's briefing, they talk about a case from Georgia, and the instances, the facts of that case are distinguishable because the conduct that's at issue in that happened in March. When COVID was relatively new, this guidance was being released, there was a lot of unknown. What separates the case from Georgia from this case in Iowa, beyond the different legal standards, is the fact that Oakland Manor received state and federal guidance about best practices to protect their residents in March.
I mean, that argument has some appeal, but the problem is that, as Justice Waterman's alluding to, if this were a negligence case, you might have negligence per se based on violation of a regulation. You at least have violations of some guidances that have been issued. But how do we, without some evidence of standard of care or what any, beyond just that total conclusion by Nurse Mincer, how do we know that this amounted to recklessness? How do we know that this was, so far out of the range of what was acceptable at that point in time? So, we don't know that.
The court could conclude that there was recklessness because of the duration and the pervasiveness of the conduct that's alleged. And again,
What was the effect of the immediate jeopardy rating that the facility received?
the result of the CMS report was a finding of immediate jeopardy. And this is important because when we talk about recklessness, we talk about the language of understanding harm that is going to come. I'm trying to find the exact language here, but the exact language is about understanding that the gravity of the harm. In the context of the pandemic, the Oakland Manor was made aware in March and April, but the result of the CMS report said immediate jeopardy, which means that there is immediate, there's immediate danger to the residents. Oakland Manor has to take immediate steps because of conditions at their facility.
Though, I mean, doesn't that really go to the timing or probability of an injury, but not the quality of the provider's care or conduct? Right, so the Code of Federal Regulations says immediate jeopardy means a situation in which the provider's noncompliance with one or more requirements has caused or is likely to cause serious injury, harm, impairment, or death of a resident, but it doesn't really talk about reckless conduct.
And I think we get to reckless conduct because of the pattern and the pervasiveness from March to July, despite interventions from local health authorities in April, and state and federal resources being consistently sent out to facilities like Oakland Manor and Oakland Manor in particular. I have run out of time. Okay.
More. I just want to get an issue out before the break. Could you hit on causation? Because I am struggling with the concept that we can really say that even assuming there was that COVID was a cause of death, that what particular acts by the nursing home staff led to that COVID death?
Fundamentally, what you're asking is a question for the jury. The operative case on that would state that, and I'm reminding myself of which case that was. However, it's not that the jury will or must find that there is causation, but that they might find. And in this case, we allege sufficient facts that could allow. And I think the concern here is burden shifting. The standard here shouldn't be that the plaintiffs, in this case, that we prove that all alternative theories of causation are false, merely that we allege one that might be true and could be found by a jury when presented to the jury at trial. And so I think, to get to your question, one, it would be more properly and more justly resolved as a question of fact for the jury. And in addition to that, being prepared for being presented to the jury, shifts the burden. That was the second part of that. Does that answer your question, Justice?
May it please the court, counsel. The district court and the Court of Appeals properly dismissed the plaintiff's claims in this matter pursuant to Iowa Code 686D.6, which creates immunities for healthcare providers under the pursuant to COVID-19 care and treatment of patients. It certainly includes nursing homes and states that no civil damages for acts or omissions while providing care in support of the state's COVID-19 response, including the variety of things that the plaintiff alleges here, quite frankly, are designated by statute as creating immunity unless, of course, there's recklessness or willful misconduct. Importantly, simply because there's a violation of a statute or guidelines, that does not equate to recklessness. And this court said a couple of years ago in Martinez, of course, that proving recklessness is a difficult standard to meet. Yes.
Wrong when it said that it granted summary judgment because the employees were not intentionally acting to spread COVID-19. Is that the standard that we're looking at?
I think the standard that we're looking at is, was there an intentional act that was unreasonable?
Evidence that the employees were actually intending to spread COVID-19?
I don't think they had to make that specific of a finding.
Fine, on that standard.
They were wrong to make that finding other than to say their obligation.
The standard, though, it wasn't just a finding, it seemed to be the standard the district court was applying.
The standard calls for an intentional act of an unreasonable nature.
Like, this is what the district court said. A finding of recklessness requires a showing that an act was intentionally committed in disregard of a known or obvious risk. Is that? Yes. Yeah, and that's recklessness.
Yes.
Okay.
Yes. the this court for 30 years has defined recklessness, starting with Morris, Leonard, Martinez, cited recently in the Tyson Foods case as well. It's relying on the restatement, second of tort section 500, that a defendant has intentionally done an act out of an unreasonable character in disregard of a known or obvious risk, so great as to make it highly probable that harm would follow. So,
And here that we have Nurse Mincer, who's issued her report, and she said that based on her experience and I guess review of this CMS report, that there is enough here to show that there was wanton conduct, and that we should interpret, we should view these facts in a light that favors the plaintiff, right, the non-moving party, and that this is just kind of being too nitpicky.
well, let's start with the higher difficulty of proving recklessness. I think the court today already has mentioned the concept of this maybe rings of negligence, and I think the district court and the Court of Appeals said as much. Certainly, recklessness is often a jury question, but it requires a certain foundational level of proof at the summary judgment stage, particularly in what equates to a medical malpractice case against the nursing home. And the Nurse Mincer offers nothing other than what they said in the CMS report. And that is wanton. First, she says they acted negligently and in wanton disregard of the findings or of CMS guidelines. So
in wanton disregard of CMS guidelines is not necessarily in wanton disregard of a known or obvious risk, such that harm, that.
You've hit on an important distinction, and I think that matters. But she offered, you had a discussion with appellant's counsel, and I'll hit on it briefly as well. There simply is no admissible evidence that she relies upon to offer testimony as it relates to this CMS report. She does nothing to link any of it to Mr. Rose. It's simply a conclusory remark that says, well, you didn't follow these guidelines, ergo it caused his death. There's nothing to say which, if any, of those things were specifically related to Mr. Rose and how he contracted COVID-19 and how he was treated otherwise. And so, and I think the timely mission case this court decided a few years ago addresses, and I recognize that was at trial as opposed to summary judgment, but timely mission addresses this very thing. It says, both on a hearsay basis and under the rules governing expert testimony, it's just too prejudicial to.
Unless my recollection is wrong, you didn't challenge the affidavit in the CMS report on hearsay grounds. Is that right?
I think we did. I think that was a basis for part of our motion. If I'm wrong, I apologize. My recollection is that we said, look, there's no foundation here. You can't get there because the CMS, relying just on the CMS report is insufficient.
Maybe I missed that. I thought in a reply brief, you mentioned or used the word hearsay, but I didn't know it was an independent argument that all of it should be excluded.
It was certainly intended to be. How's that? It's my understanding, and certainly something we would have talked about at oral argument as well.
I have a footnote where you point out the Court of Appeals recently said these reports were inadmissible hearsay in another case. And then, this is in your, as I understand it, there were dueling summary judgment orders. The district court requested each side to prepare its version of what it wanted. Your version kind of raised the hearsay objection. You said the CMS findings, to the extent they would be admissible at trial, don't raise an issue of fact. And then a footnote, you point out the Court of Appeals recently said those reports are inadmissible hearsay. So if we grant that, that's an objection, if we consider it. But that's the extent of the record, is that correct?
That's certainly fair. The CMS report, as we know, identifies these collection of things that they suggest we didn't follow or we didn't do.
Or resulted in this immediate jeopardy. And the report itself at least defines that and says that noncompliance cited at the immediate jeopardy rating is the most serious deficiency type. An IJ situation is one that is clearly identifiable due to the severity of the harm or likelihood for serious harm, and the immediate need to be corrected. Does that clearly identifiable go to the intentionality of the underlying acts, the fact that the staff were not following the COVID-19 guidelines?
One, I think that applies more to the endpoint outcome as opposed to how or why they were acting the way that they were. Secondly, I don't believe that the ultimate findings of the CMS report, the penalty that the CMS issues, and this finding that you're describing as immediate jeopardy is even admissible. I would liken it to a motor vehicle accident where there's a finding of guilt for a traffic accident.
Decide about admissibility. What kind of acts could rise to the level of recklessness with respect to a facility just not following the guidelines from COVID-19?
Let's start with this conversation, the CMS report and the briefing about isolation, an isolation area. If you just didn't have an isolation area, you just put everybody back together right where they were. You had the Hendricks case from Georgia, recognizing it was a case arising from care in March of 2020. They had a St. Patrick's Day party. They had a van ride with a bunch of people together. There was no social distancing, all of which were found to still not be reckless. But I mean, it's the idea of an isolation area that you didn't have. The criticism of us is that we had an isolation area, we just didn't manage it correctly. The criticism of us on PPE is you wore masks in the isolation area, but you didn't wear a gown or you didn't change your gloves. And of course, the statute specifically says that PPE use or misuse or non-use is specifically a protected thing. And if you went in, even Hendricks talks about the staff was going without PPE, still found not to be negligent. Now, fast forward from March to the summer when this happens, and that might be different. But we were using PPE, just not as effectively as the government wanted us to.
How does that affect the analysis if the amount of time it went on, and was this the first time that you're notified that, hey, you're not doing things right, or were there prior?
There had been some guidance given in April that they attempted to implement, and then this, of course, arises from complaints that they then come in and do an investigation and come to this immediate jeopardy conclusion, which makes the CMS report a hearsay document. Now, and then I'll note for the court that the plaintiffs have identified no witnesses up to the time of summary judgment, initial disclosures, discovery, or otherwise. It's the two plaintiffs and their expert are the only witnesses that they have that could offer any testimony. They didn't identify any people at our clinic or anything of the sort to say, I can establish the facts that the CMS report says. All they've got is the expert who's relying on a report that she can't testify to per timely mission, and the two plaintiffs who hadn't even ever visited their dad, I think, according to the record. All of that ties to what you said, what kind of things could make this matter. I mean, if we had let's call it a 4th of July gathering where we brought everybody together in the cafeteria area with no social distancing, no masking, no nothing, while knowing that half of the staff was sick, we invited people in from outside and we had a big party. Or the recent Tyson Foods case, this court decided earlier this year, where they're betting on COVID-19 patients. They're telling interpreters to lie to,
Probably goes to wantonness even more than recklessness. But is there,
it may be, I'd say the challenge of navigating what one is versus the other is a difficult challenge. I'm not suggesting otherwise.
Made that given the population inside the facility and the potential risk of harm, the likely risk of death, that under our recklessness standard, even small acts may be considered recklessness because of the magnitude of the risk of harm.
I would say that that's putting a burden on a nursing home that the statute in some measure was designed to prohibit. I appreciate the statute creates the exclusion for recklessness, but the idea, the public policy, if you will, behind the statute was we don't want nursing homes and health providers to be hauled into court with regularity and a fight over even the smallest of things being culpable. Now, can it be? I think it requires something relatively egregious. Maybe it's not betting on the number of COVID patients.
31 residents contracted COVID. How does that play in?
Well, again, question whether that's relevant. It may be, but 30 of 31 residents, I'm not sure our nursing home was alone in regards to having huge numbers of patients that had that developed COVID, staff that developed COVID, and it feels like a difficult line to set to say 90% makes it a reckless, or 75%.
Itself, but does it at least, is it a factor to consider as far as recklessness, as far as kind of to the extent of the facility's knowledge of the acts that I'm doing by not being strictly following the guidelines, it creates serious dangers?
I'll tell you that I don't know the answer to this, what I'm about to say for sure, but we don't know in relation, remember this isn't a case by all 30 residents against our nursing home. This is a case by Mr. Rose's family regarding Mr. Rose developing COVID. And I don't know the answer, and I apologize as to how many of those 30 had passed away at the time that we were giving care to Mr. Rose, or if we knew all of those things after the fact. And I'm out of time. I'm happy to answer any questions if the court desires.
That there's not evidence in the record about the rate of infections and deaths at other comparable nursing homes. Thank you.
Thank you, Your Honors.
Mr. Johnson?
Opposing counsel is a little taller than I am. Your Honors, let's take a step back and recognize the scope and gravity of what happened. The record bears out that 30 of 31 residents contracted COVID, 17 staff contracted COVID, and 7 died.
Could I come back to that same question with you? Because that does sound obviously like a bad situation, but does our record tell us anything about what was happening in comparable nursing homes?
It can be inferred from the immediate jeopardy rating. In the CMS report as immediate jeopardy is the highest level of danger rating that CMS would conclude, which comes across a spectrum of conclusions. And so the court can conclude, while I don't believe and I don't want to argue facts that aren't in evidence if there's not any specific evidence about rates of COVID in nursing homes, I think it can be implied from, and I think it's a reasonable implication, that because there's an immediate jeopardy rating, that CMS saw something extraordinary happening and that there was an extraordinary danger.
Helpful if you know, Nurse Mincer had been qualified to explain that and say that, but all we have are the reports. And in any event, you know, as I'm looking at Rule 5803, there is a hearsay exception for public records, and we talked about factual findings, depending on the nature of the report, might come in, but there's nothing that says that legal findings like this jeopardy rating come into evidence and would be subject to a hearsay exception, right?
I want to address one comment in the beginning of that, which was the competency of Nurse Mincer. Now, Nurse Mincer's affidavit, the expert can rely on this report, and also I would argue that even if, and our argument isn't that it should be excluded by hearsay, obviously. However, even if it is, it still can be utilized at trial in front of a jury for other purposes. And I think that's important for the court to consider. But I also think what's important for the court to consider is the context of this case and how it relates to Feld and Feld's reliance on a baseball coach, years of experience. One thing that we haven't mentioned and hasn't been mentioned by the bench is that Nurse Mincer has 10 years of experience in a skilled nursing facility in the area.
Go ahead.
But in Feld, the coach expert gave some very specific factual grounds for his conclusion, you know, right hand, batter, left hand, where the bat went, to reach his conclusion of recklessness. And here we just have sort of a, you know, summary conclusion that's not developed with any facts. Isn't that right?
It's developed with facts because it's relied on her experience and it's relied on the report contained in the affidavit.
She says, I'm looking at her report, the first thing she says is this was negligent care, right? So that doesn't meet the standard of recklessness. We would agree on that, right?
Right.
Then she says there's a wanton violation of federal, state, and facility regulations, but she doesn't identify those regulations, at least on that section. And so, you know, you can willfully violate a regulation, but if the violation isn't reckless because the violation doesn't relate to substantial risk of harm, that doesn't seem to me to be recklessness. And the only two specific things she identifies in terms of the conduct that could constitute recklessness is failure to follow isolation guidelines and incomplete PPE use. So that's all she opines to. I mean, I know the report has other things listed in it, but is that what we're looking at here, is failure to follow isolation guidelines and incomplete PPE use?
I have 5 seconds, if I may have time to answer your question. Okay. So, yes, in the affidavit, you stated the affidavit, the contents of the affidavit accurately. However, to draw the court's attention back to the defendant's argument, and there was a question from the bench about, you know, is there something to be considered about the level of harm and the risk of the context of this happening in a nursing home? And that relates to cases like Martinez, where the officer recognized the risk. Now, this is a skilled nursing care facility with staff that are trained in care for elderly people that may be immunocompromised. And so while the specific allegations like sound in retrospect as minor, the gravity of the harm, 30 out of 31 infected, 17 staff infected, seven dead, that demonstrates the level of harm that did occur, not even that could occur, but that did occur from the alleged actions. And that the actions and failure to act by Oakland Manor should be considered in the totality and over the course of months, which distinguishes it from other cases cited to in the record. Also, Chief Judge Tabor mentions that in her dissent, that brings up a question about how much are we going to demand of estate experts at this point, at summary judgment point, and she contends that the majority expects too much specificity from the estate's expert at the summary judgment stage, and you have that report. It's the plaintiff's argument that the Court of Appeals decision is requiring too much specificity at this point in the trial, but regardless, the specific allegations and the context in which those allegations created the harm are grave, and the people who were working in Oakland Manor knew of the risk and deliberately chose to act and chose not to act. And because of that, not only was it reckless to create harm, but it did create harm. And when you consider the totality of the context, the totality of the timeline, and the totality of the allegations contained in the CMS report, you get to a finding of recklessness.
The case of Estate of Jack Rose is hereby submitted.